This courtroom hearing might look routine at first, but within minutes, it reveals a series of tense legal decisions, negotiations, and a surprising guilty plea that could change everything. From arguments over alcohol monitoring conditions to a debate about whether a questionable car stop could unravel an entire case. Today's courtroom session is packed with legal strategy and high-stakes consequences. Watch closely as attorneys challenge the court. The judge weighs financial burdens against public safety concerns, and one defendant ultimately faces a life-altering admission in front of the bench. But the real question is, are these legal moves about justice, or simply about damage control? Let's break down exactly what's happening inside this courtroom.
Good afternoon, Your Honor. Charlotte Stephan on behalf of Ms. Allen. Your name for the record. Okay.
No, go ahead. All right.
Your Honor, we are in negotiations with the people, and the defense would like to request an adjournment for that purpose. Also, and I apologize, I forgot to bring this to the people's attention ahead of time. I did want to address one of the bond conditions, if the court will allow.
Trying to surprise Mr. Cook? No, it's okay. It's okay. Just well with that.
I think he can handle it, but I'm not trying to surprise him.
Go ahead.
Oh, it's pertaining to her, the sober link. It's a cost issue for her, and so we are requesting random alcohol testing.
Right away, the defense is raising a financial concern about a bond condition, specifically the SoberLink alcohol monitoring system. Now, SoberLink is essentially a remote breathalyzer program that requires defendants to submit daily tests, and it can quickly become expensive over time. The defense is asking to replace that with random ET testing, which detects alcohol in the system through lab tests. But here's where things get interesting. While random testing might seem cheaper on the surface, it also reduces continuous monitoring. And when a case potentially involves alcohol-related behavior, judges often hesitate to loosen oversight. So the real question becomes, should financial hardship outweigh the court's desire for strict monitoring? Let's see how the judge navigates that balance.
Instead, random ETG alcohol testing instead.
Well, if I had random ETG, she'd have to take one every week randomly. And I'm not clear that her cost. I don't know what the difference in cost would be.
Oh, I understand what you're saying. I think the SoberLink is $6 a day. Is that right?
Yeah. I think to
Well, no. Out how much an ETG test is, if there had to be a confirmation on it. Let's do this. So how much time did you need?
Would 2 weeks be agreeable with the court and the people?
That's fine with me.
Thank you, Your Honor.
Probable cause conference will be adjourned to March 26, 2026 at 9. Bond will continue. Mr. Cook, are you going to have a position on that?
And there it is. The prosecution introduces a critical detail: a 166 blood alcohol level. For context, that's more than twice the legal driving limit in many jurisdictions, which instantly reframes this discussion. What started as a financial argument now becomes a public safety concern. The prosecutor is essentially saying, if the defendant was that intoxicated before, loosening monitoring could be risky. Notice the strategy here. Prosecutors often highlight specific facts like this to remind the court why strict bond conditions were imposed in the first place. It's a subtle but powerful move. Now, the judge has to weigh two competing factors: the defendant's financial burden versus the potential danger to the community.
I would ask if the court does do random testing at least twice a week. My reason for asking that is the BAC, from my recollection, is 0.166. I believe there was a crash, and the defendant didn't discharge a firearm during that crash. So I think there's serious safety concerns as it relates to alcohol, and having that bit of a closer look at the defendant's sobriety and oversight would be a good idea.
So you're suggesting no change?
No change for the court's going to do random testing at least once per week.
Twice, 2 times a week. All right.
Your Honor, if I may, I'm not disagreeing with the allegations as reported by Mr. Cook. However, I would note that thus far,
This is a classic defense strategy. Acknowledge the allegation, but shift focus to the defendant's compliance record. Instead of arguing about the crash itself, the defense emphasizes that the defendant has followed every monitoring rule so far. In court, consistency matters. A clean compliance history can sometimes persuade judges to soften conditions. But here's the tricky part. One serious incident can outweigh months of good behavior, especially when alcohol and public safety are involved. So the judge now has to decide whether the current system is truly necessary or if it's financially punishing someone who has otherwise followed the rules. That balancing act is exactly what makes these bond hearings so unpredictable.
she's been compliant with the SoberLink. There have been no issues. Prior to this incident, she's had no previous issues with alcohol, and she has no drug history at all.
Okay. What I will do with reference to that is momentarily before you leave, what do we have it?
So it's $15 for the initial test and then a confirmation test and you just $30.
So $6 a day, 42 a week. But to do, and I could think defer to the people. So she did 2 ETGs, gonna be doing 30 a week. Savings of $12. Unless one comes back positive, which she would likely want to have a confirmation test, which is then gonna cost her 30.
Confirmation.
Oh, we'll come back to that. So there's a matter.
Okay, I see.
Do you want to switch to that?
I think so, yeah.
I'll tell you what I'm gonna do. I'm not gonna make a change at this point. You're coming back in 2 weeks.
In the end, the judge makes a cautious move, no immediate change to the monitoring condition. Instead, the court postpones the decision for 2 weeks. This type of ruling is actually very common. Judges often prefer to gather more information rather than make a quick adjustment that could later create safety or legal issues. It also gives both sides time to present clearer cost comparisons or compliance updates. Think of it as the court pressing pause rather than hitting reset. But the hearing is far from over because the next discussion dives into a completely different legal issue involving an appeal and a potentially questionable car stop.
Look at it, and then I will make a decision.
Okay,
26.
thank you,
Okay.
Judge. We appreciate the consideration and the information from your staff.
Thank you. I was expecting to see him on,
Introduce yourself. Jeremy Shu.
I know Mr. Shu.
Thank you.
Had our moment. All right.
Denied the Zoom hearing.
Yeah, all good and getting better, Your Honor. Mr. Shu is here in person. I wanted to ask the court to consider a motion to stay. We're in the same holding pattern that we have been. He has a pro per interlocutory appeal on a companion case, and that companion case involves the same series of episodes and the same car stop that is the subject of his interlocutory appeal. Last time we were here, Your Honor continued it rather than staying it just to see what would continue to happen in the Court of Appeals. What has happened is they dismissed on administrative grounds. Mr. Shu filed a successful motion for reconsideration. They've now, because it was just an administrative dismissal, it never got to the merits. They've now reopened it, and it's continues to be on a leave application.
Okay.
And rather than come back every few weeks, we're asking the.
So I guess I'm a bit confused. I'm a bit, I won't say confused, but want to make sure I have an understanding of how the decision in that appeal affects this case?
Sure. So there are a series of alleged episodes that took place in a neighborhood, some items that were allegedly taken. And the first case is a misdemeanor case in Judge Washington's courtroom involving the first set of items that were potentially recovered in a car stop, or at least items that might look like those items. This arrest came many months later, involving another house in that same neighborhood in that same period of time, and also involving things that were found in that car stop. So if that is a bad car stop, then that impacts this case as well.
I see. So it's really, I see what you're saying. Do the people have a position?
We'll leave it up to discretion of the court.
Uh,
I would leave it up to discretion of the court on objection.
Here, so my other issue with granting a stay, which is, I mean, I get why you would want that to happen, but are you asking in essence for an order similar to that was signed by Judge Washington?
That's right, an identical order, and I'll keep the court up to speed as things develop in the Court of Appeals.
All right.
She set a status date for a few weeks from now.
Status date for March 26th, but I wouldn't do that. And how, I'm just thinking timing wise, I'm not sure how fast or slow the Court of Appeals is operating at this point.
Yeah, I mean, I have to be honest, I'm really surprised that it's taken this long, but and I may have been because of the initial administrative denial, but it doesn't seem to be moving anytime soon on this.
All right, what I'll do is I'll order it stayed with the next court date being, I'll just go a month out from there, April 23rd. (2026) for status.
Now, this part of the hearing introduces a fascinating legal twist. The defense is asking the court to pause this case while an appeal is pending in another related case. Why does that matter? Because both cases allegedly stem from the same car stop. If that stop is eventually ruled unlawful by an appellate court, it could undermine the evidence in multiple cases at once. That's why the defense wants a stay, essentially freezing the case until the higher court rules. And the judge's response shows careful legal reasoning. Rather than dismiss anything outright, the court schedules a future status date and allows time for the appeals process to play out. It's a reminder that sometimes the biggest courtroom battles happen long before a trial ever begins.
And then I'll just adjourn the way we'll have to do it here, since it's not my misdemeanor or my district court docket technically, is I'll have to give the probable cause conference that date. Okay. Effectively kind of a stay, but.
No, that works, Your Honor, and I'll be in touch with your staff and with Assistant Prosecutor Childers as their developments, and in advance of that date, if it's still in limbo.
Yeah, if it's still in limbo, and so that I'll state this on the record, my staff will remember this. If we still don't have a resolution, now that I can appreciate what you're saying in terms of the case itself, I'm not going to have a problem adjourning it by stipulation.
Okay.
Say a month out, so we'll just see where we are.
Great. Thank you, Your Honor.
All right. Thank you.
Next time.
Please state your name for the record, Joe. Joseph Smith.
All right. I think I may have a plea form,
Correct, Your Honor.
and that would dismiss that one. Okay. So the plea form indicates that he's going to plead to count 2 of use of a controlled substance, that being cocaine, the 1 year offense. Upon a successful plea to that charge, or count two, count one would be dismissed. And so I'm also clear, this is taking place in the case 1915.
Correct.
And then upon a successful plea in that, to that count two in that case, count one would be dismissed in that case, as well as there would be a dismissal of 25 FB 1343 FY. And that is the entirety of the court's understanding.
Yeah, I believe we're going to file a nolo. Go ahead.
Yeah, I would file a knowledge on the, it's on entry of the plea, although my wireless.
Okay.
But yeah, that's what we're doing today.
All right. May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Joseph Smith.
All right, Mr. Smith, it's this court's understanding that you're going to plead guilty to the charge of use of cocaine. Is that your understanding?
Yes, yes.
That's a misdemeanor, punishable by up to 1 year, $2,000 fine plus court costs. You understand that, sir?
Yes,
All right. And understanding that, you still wish to plead guilty,
I
right?
do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
yes.
Any question regarding any of those rights?
No,
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
yes.
Were you on probation or parole at the time of this offense?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No,
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
I am.
And because you believe that you're guilty of this offense?
No.
Well, for whatever reason, they don't have my information out, but that's okay. I can find it this way. Sir, on the date, February 3rd, 2025, at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes,
Had you used it?
yes,
Did you know what you were using was cocaine?
I did.
Okay. Sir, I do have to advise you that if I accept your plea, between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
I do understand it.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
And none by the defense, Your Honor.
And have I complied with the court?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be April 8th, 2026, 9 a.m. That's before me. And also 25 FB 1343 is word dismissed. Signs off on that. Okay.
Perfect.
Bond continued. Thank you.
Thank you, Your Honor.
Thank you, sir. On your way out.
Now, this part of the hearing introduces a fascinating legal twist. The defense is asking the court to pause this case while an appeal is pending in another related case. Why does that matter? Because both cases allegedly stem from the same car stop. If that stop is eventually ruled unlawful by an appellate court, it could undermine the evidence in multiple cases at once. That's why the defense wants a stay, essentially freezing the case until the higher court rules. And the judge's response shows careful legal reasoning. Rather than dismiss anything outright, the court schedules a future status date and allows time for the appeals process to play out. It's a reminder that sometimes the biggest courtroom battles happen long before a trial ever begins. 9/55/1412 Guilty plea of Joseph Smith for cocaine possession. VO7 final summary and CTA after 14/12, and just like that, The hearing concludes with a guilty plea that brings a clear resolution to one of the cases before the court today. The defendant admits to using cocaine, accepting responsibility for a misdemeanor offense that could carry up to a year in jail and significant fines. The judge carefully walks through every constitutional right being waived, from the right to trial to the right to appeal, ensuring the plea is voluntary and legally sound. A pre-sentence investigation is now ordered, meaning the court will review the defendant's background before determining a final sentence. Moments like this show how courtroom proceedings often blend negotiation, legal strategy, and accountability all in a single session. But what do you think about these decisions today? Should the court have reduced the alcohol monitoring costs earlier, or was the judge right to prioritize safety? And how much should a questionable police stop affect other related cases? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.